Hello everyone, welcome to Legal Darshan. In today's video, we are going to discuss the case of Cox and Kings Limited versus SAP India Private Limited and another. It is a case based on arbitration and it is listed at number 75 in the list of AOR leading cases. Now, in this case, the court, the five judges bench, the court is examining whether the group of companies doctrine is applicable in Indian arbitration jurisprudence or not. Basically, this matter was lying before a three judges bench, but however, for examining the validity of group of companies doctrine, this matter comes before a five judge bench. And before we proceed into the merits of the case, into what has been decided in the case, it is important to know what group of company doctrine is. Now, group of company doctrine realizes that companies within the corporate group, okay, so companies within a corporate group, even though they are legally separated, they can be treated as one single economic entity, for the purpose of dispute resolution. Now, what happens with application of this doctrine is that one company may have its affiliate companies, right? So now it allows non-signatory companies within a group to be bound by an arbitration agreement which is signed by another company affiliate within the same group. And but however, it is subject to the condition if it is determined that there was a common intention to bind all the parties to that arbitration agreement. So basically, it provides that an arbitration agreement which is entered into a company within a group of companies, within a group of corporates, may bind non-signatory affiliates as well if the circumstances are such as to demonstrate the mutual intention of the parties to bind both the signatory parties as well as the non-signatory parties. Now, this particular doctrine is put into the question that whether, we can use it, we can invoke it in the Indian arbitration jurisprudence, because it can be interfered with the grounds of some legal principles like autonomy, like privity to contract and separate legal personality, right? So now, when we come to the facts of this case, what is happening in this case is that there is one company, Cox and King. Cox and King is coming into an agreement with SAP India. Okay, now it is coming into an agreement with SAP India for some software designing and for manufacturing of a software for their own company. Now, what happens is that a dispute arises between these two companies with respect to the timeline of completion of the designing of the software, right? So basically, there is a dispute that is arising because even after taking extensions, SAP India, which came in the contract with Cox and Kings, it could not complete the work. It could not, complete the software that it promised for. Now, this agreement, the agreement that Cox and King and SAP India signed, it had an arbitration clause that if things do not go as planned and if there arises any dispute, then arbitration will be used as the dispute resolution mechanism. Now, what happens that Cox and Kings goes for the appointment of arbitrator under Section 11 of the Arbitration Act in the Indian court. And however, the Cox and King also makes SAP SE the party. Now we need to understand one thing, that SAP, the contract is between Cox and Kings and SAP India. And SAP India is the body, is the company operating under the parent body of SAP SE. Okay, now the contract lies between these two. But Cox and King does what? When Cox and King invokes the arbitration clause, Cox and Kings also make SAP India the respondent and also make the parent body SAP SE, which is situated in Germany, also the body of also the respondent in this particular case. Now, the court herein are faced with an issue that even though SAP SE is not a signatory to the contract, it allegedly got involved in the project. Eventually, because the implementation failed, Cox and King terminated the contract. Dispute arose because Cox and King made a demand of recovery of 45 crores that they have spent for the software. And Cox and Kings are therefore approaching the court And they also wanted that SAP SE, which is situated in Germany, it should also be a party even though it hadn't signed the agreement. Now the question is, can a non-signatory like SAP SE, which is not the signatory to the agreement, can it be made a party to arbitration under the Indian law? Now the court herein are looking at the doctrine of group of companies doctrine, right? Now, as discussed, this particular doctrine, it allows, okay, this is what we are coming to the decision. Yes, so it allows, group of company doctrine allows that a non-signatory company shall be bound by an arbitration agreement if it can show that there is a common intention of party and the non-signatory party did play a vital role in the transaction. Okay, now this doctrine has been used before the court. Okay, has been used in various benches. There are various benches in which we are using which group of companies doctrine has been invoked. I remember that once when I was also interning in the high court, in one of the high courts of the country, in arbitration roster, there also we have used group of companies doctrine for dispute resolution between two parties in an arbitration dispute, right? So now court is also saying that even though a five judges bench, a constitutional bench, did not even recognize its existence, but this doctrine has been used so far in the Indian jurisprudence, and now a five judges bench is confirming the application of group of companies doctrine in this case. Now the court herein is holding that this doctrine is a valid doctrine and it is rooted in the principle of implied consent. Now when you have to adjudicate, now the courts are also saying that whether a non-signatory can be a party to the dispute, this question has also this question can also be adjudicated by the arbitrator, because it is falling in his jurisdiction. So court herein is also looking at the competence principle, while saying that the arbitration tribunal has the power to also decide whether the non-signatory affiliate, whether the non-signatory party can be made a party to the, can be made a respondent to the dispute or not. Now how will you decide, what are the parameters based on which one will decide that whether this non-signatory affiliate can be made a party to the dispute? Is the court is laying down some conditions, some parameters, that you have to evaluate the relationship between the signatories and the non-signatories. What is the role of non-signatory in the performance of that contract, and whether the nature of the transaction that is resulting out of the contract, does it indicates a common intention to bind signatories and non-signatories as well? And then you have to look for the rooted principle of the implied consent, right? Now this doctrine, however, is not similar to the doctrine of alter ego or piercing the corporate veil, but it is corporate separateness, that we respect there is a separate entities, affiliates are the separate entities, but it also recognize commercial realities, that in case one affiliate, if is going out of the line or is committing some kind of corporate fraud, then in that case another party can be made, another affiliate of the same group of companies can be made respondent, or can be made a party, to understand the commercial realities around, right? So now this is what the court is basically laying down in the Cox versus SAP India case. Court is basically also looking at two sections, section 21H and section 7 of the Arbitration Act. Now, Section 7 lays down what is the meaning of arbitration agreement, and whereas when we look at Section 2 subsection 1 clause H, it means that it is defining party, and it defines party as a party to the arbitration agreement. Now court herein is basically saying that if you read the definition of parties provided under section 21H and read it along with section 7, it will include both signatories as well as non-signatory parties, and the conduct of the non-signatory parties could be one parameter to adjudicate whether there is an implied consent to the arbitration agreement or not. Now the requirement, okay, so now in this, what happens in section 7 is that it is prescribed that the agreement shall be deduced in writing. But herein the court is also saying that when there is a prescription of having the arbitration agreement written, it does not exclude the possibility of also binding a non-signatory party. Okay, now an arbitration act, the court herein is saying that party is distinct and person claiming through or under a party to the arbitration is also different, right? So now court basically says that doctrine of group of company doctrine rests on corporate separateness, as well as it also helps to determine the common intention of the parties, so that a non-signatory affiliate of the same group of company can be bound to the arbitration agreement as well. And thus the court herein is ruling out that we do stick to the group of companies doctrine, and that is applicable in the Indian arbitration jurisprudence. However, the court is also looking at one case, one landmark case in the journey of arbitration discourse in India, which is the chloro controls versus Seven Trent water purification. It is a 2012 case, right? Uh, this case is basically holding that when the chloro controls is using claiming through or under phrase as given in section 45 of the Arbitration Act to establish the principle of group of companies doctrine, it sounds erroneous because it goes against the well established principles of the corporate law, right? So it is sort of overruling the approach that is also being taken in the case of chloro controls, but upholding that group of companies doctrine should be retained in the Indian arbitration jurisprudence, considering its utility in determining the intention of the parties, number one, and also the complex interactions, complex transactions that might occur, which involve multiple party or multiple staged agreements, arbitration agreements, right? Now the court herein is laying down that in what conditions will when we invoke group of companies doctrine, in what conditions we have to analyze whether a non-signatory affiliate of the group of country can be made a party to the arbitration agreement, and court is remanding this matter back to the bench for the factual determination. Now court herein is also holding that if to determine whether group of companies doctrine apply, it also has to be the duty of the arbitration tribunal to see and to find, to factually determine whether the non-signatory body can be made a party to the arbitration agreement or not. So this was it for the video on Cox and Kings versus SAP India Limited. This was case number 75 in the list of AOR leading cases. Now let's move on to the next case, which also relates to the arbitration regime in India. This case is titled as In Re Interplay Between Arbitration Agreements under the Arbitration and Conciliation Act of 1996 and the Indian Stamp Act of 1899. Now this is also this is numbered at 76 in the list of AOR leading cases. So both 75 and 76 are relating to the arbitration discourse in India, whereas Cox and Kings was basically related to group of companies doctrine. This case is dealing with the stamping of the arbitration agreement. However, the question, because if you see the title, the courts have given it a title like this so that you can understand that what is the play between arbitration agreements which are formed under the Arbitration Act and the Indian Stamp Act. Now the names of the statutes that have been used herein are self-explanatory. They are talking somewhere if a common reader sees the name, we know that they are talking of stamping. What is the validity of a stamp, or whether non-stamping of arbitration agreement decreases its legitimacy or what. So now the issue for the consideration before the bench is, it's a 7-judge bench decision, and the issue which is in the hands of the judges is that whether the Stamp Act, whether the arbitration agreements, so whether the arbitration agreements become non-existent, unenforceable, or invalid if the underlying contract, because it is a contract for which we make an arbitration agreement for if there is any dispute that might occur. So the question is that whether if the contract is unstamped, right, whether the such arbitration agreements would also become non-existent, unenforceable, or invalid. Now this basically this comes as a this petition comes as a challenge before the Supreme Court in form of a curative petition as against the order of NN Global, which is a five-judge bench order, and the judgment is basically trying to harmonize the provisions of Arbitration and Conciliation Act and the Stamp Act of 1899. Now, what is being held? Okay, now we directly come to what is being held in this case. Now, if you look at the moot question is that whether an unstamped or inadequately stamped, okay, whether an unstamped or inadequately stamped contract or agreement, it is valid and enforceable under Indian law. And when when the arbitration agreement is a part of it, what is the fate of arbitration agreement, right? So in this case, the court is basically looking at, okay, so the court is looking at the previous three judgments. The first judgment is, yes, so the first judgment is NN Global Mercantile Private Limited. And it is in this case, a three-judge bench is affirming the separability doctrine. The three-judge bench is saying that non-payment of stamp duty would not invalidate the arbitration agreement, because doctrine of severability says that arbitration agreement can be read in separate with the main contract, right? So that is doctrine of severability. Now, this judgment, which is given by the three judges bench, it is basically harmonizing, or it is basically promoting the arbitration regime in India. Now, this is the three judge bench decision, and you know what is happening in this judgment? It is basically separate it is basically deviating from the view that is taken on the same issue in the case of Vidya Drolia versus Durga Trading Limited Corporation. Now, this particular because that NN Global Mercantile was a three-judge bench decision, and Vidya Drolia is also a three judges bench decision. So, what will prevail? The question, therefore, was referred to the five-judge bench and it is passing the order in the same NN Global Mercantile 2023 case. Now, this matter goes before a five-judges bench, and the approach that is being taken by the NN Global case, by the five judges bench in an NN Global case, is basically that is basically supporting the argument of Vidya Drolia. Now, if you if you invalidate such arbitration agreements, it is basically an increase in the burden of courts. It is also in delaying the process of appointment of arbitrator, which of course delay the process of arbitration. And NN Global 2, the five judges bench decision, which is the second litigation happening in NN Global, it is basically opposing the direction of arbitration in India, when everyone across the world, all the arbitration jurisdictions are upholding the validity of an arbitration agreement in such an understamped or inadequately stamped instrument. So basically, now there is a curative petition that is lying before the court in this case, which is in re arbitration agreement under the Arbitration and Conciliation Act and the Indian Stamp Act. Now, NN Global is basically saying that arbitration agreement with an unstamped contract goes unenforceable. Criticism happened, curative petition is being filed, and now yes, and now a seven judges bench. Now, a seven judges bench, which is basically led by Justice Chandrachud, is unanimously overruling the five judges bench second litigation happening in the NN Global case, right? Now, first thing that is held herein is that an arbitration agreement is not ipso facto void or unenforceable only because it is a part of unstamped or insufficiently stamped contracts, right? Section 35 of the Indian Stamp Act, it says that these agreements will be inadmissible as an evidence if they are not duly stamped, if they are inadequately stamped, or if they are not stamped at all. But then that is a curable defect. Okay, so there is we always say when we read CRPC or when we read procedure, when we read CPC, there is a notion that procedural lacunas or curable defects, curable procedure, it should not hinder the access to justice because they can be reformed, they can be cured. These procedural defects, procedural lacunas can be cured. So procedural lapses can never override the spirit of substantive justice. And this judgment is aligning with such, principle as well. Now, the court herein is saying that while, such agreements may be inadmissible as evidence, right? But you cannot render them invalid. And these agreements are these defects that are arising because of non stamping or because of inadequate stamping, it is a curable defect and it does not affect the validity of the agreement, right? So now the court is also basically looking at section 8 and section 11 of the Arbitration Act, and court is saying that even if there is stamping issues, court should not refuse to refer parties to arbitration under section 8 or 11 of the Arbitration Act. Okay, so court can invoke arbitration clause, court can appoint arbitrator, and court can initiate arbitration proceeding under 8 or 11 of the Arbitration Act, just and does not delay it, or does not court should not refuse to refer the parties to arbitration because merely procedural issues with respect to stamping exist. Now, the case can be taken up by the arbitral tribunal, and the arbitral tribunal, in the exercise of competence principle, have the power to rule out the validity or invalidity of the arbitration agreement, right? Now, court herein is also invoking the doctrine of severability. Okay, so court herein is saying that arbitration clause, it is a well settled principle of arbitration law that arbitration clause is separate from the main contract. So even if your main contract is unstamped, the arbitration agreement shall remain valid also. Okay, so doctrine of separability is also being invoked in this case, right? Now, when we look at that, the matter should be referred to the arbitration bench, and invoking the competence principle, arbitral tribunal do have the competence to rule on their own jurisdiction. They can also, decide, they can also adjudicate the issues relating to existence and validity of the arbitration agreement. Now, this judgment, this seven judges bench judgment, it is reinforcing the pro-arbitration stance that India is portraying, that India is keeping up in the global world, right? In the across the global jurisdictions. Now, it also reduces potential burden on court that may arise due to prolonged litigation in such cases. It also reduces procedural obstacles to arbitration. It ensures that these are procedural technicalities, and non-fulfillment of procedural technicalities, as we were discussing just now, it should not derail the litigation proceedings or the arbitration proceedings, and it should not prolong the injustice that may be caused. Now, this judgment also aligned Indian arbitration law with best international practices, and by clarifying the stance that stamping deficiencies are curable and it does not invalidate arbitration agreements, Supreme Court is providing in this judgment a greater efficiency or a greater degree of clarity, certainty to the arbitration process. Now, this is it for the two videos on Arbitration Act, one relating to group of companies doctrine, which is your Cox versus SAP, and another is this case, which is titled as In Re Arbitration Agreement under the Arbitration Act, interplay between arbitration agreement under Arbitration Act and Indian Stamp Act. Thank you everyone for staying in. Please keep watching and subscribing and sharing the videos. I hope the discussion is useful for you. Thank you for staying here. Have a nice day.